Hello, this is Kyllo versus United States, 2001. Facts. A Department of the Interior agent, suspicious that Danny Kyllo was growing marijuana, used a thermal imaging device to scan his triplex. The imaging was to be used to determine if the amount of heat emanating from the home was consistent with high intensity lamps, typically used for interior marijuana growth. Subsequently, the imaging revealed that relatively hot areas existed compared to the rest of the home, based on informants, utility bills, and the thermal imaging. A federal magistrate judge issued a warrant to search Kyllo's home. The search unveiled growing marijuana. After Kyllo was indicted on a federal drug charge, he unsuccessfully moved to suppress the evidence seized from his home and then entered a conditional guilty plea. The question in this case: does the use of a thermal imaging device to detect relative amounts of heat emanating from a private home constitute an unconstitutional search in violation of the Fourth Amendment? The Supreme Court, by a majority decision, decided that the answer to the question is yes. And in its 5 to 4 opinion, delivered by Justice Antonin Scalia, the court held, where, as here, the government uses a device that is not in general public use to explore details of the home that would previously have been unknowable without physical intrusion. The surveillance is a search and is presumptively unreasonable without a warrant. In dissent, Justice John Paul Stevens argued that observations were made with a fairly primitive thermal imager that gathered data exposed on the outside of Kyllo's home, but did not invade any constitutionally protected interest in privacy, and were thus information in the public domain. Interestingly enough, one of the most conservative members of the court, Justice Antonin Scalia, ruled in favor of Danny Kyllo. And not only did he rule in his favor, he actually wrote the court's majority opinion, whereas a liberal justice, John Paul Stevens, wanted the court to rule in favor of the United States and against the defendant. What we saw in this case was an interesting coalition of conservatives and liberals in order to produce this decision. We also see that this is one of the early so-called high-tech cases in which a device is used to obtain information by means other than human observation or low-tech observation. And please note that Scalia's decision hinges on this particular high-tech device not being in general public use. Presumably, if the general public were to carry thermal imagers on a routine basis, then the case would have gone the other way, because Danny Kyllo would not have had expectation of privacy. And I reiterate that expectation of privacy is a doctrine within the domain of the Fourth Amendment jurisprudence. It is not a right to privacy. So don't mix up the right to privacy and expectation of privacy. Whereas, of course, they are intellectually related concepts, expectation of privacy is applied to the Fourth Amendment. It's not a distinct right to privacy. We see here that a minority, represented by Justice John Paul Stevens, wanted to see this information, that heat that escaped Kyllo's home, just as much as any other information, let's say like trash left on the curbside for garbage men to pick up. In that case, there is no expectation of privacy. And that's the analogy that Justice Stevens wanted us to accept in this case. But the majority would have none of this. For the majority, the heat that escaped Kyllo's home was not information simply left out there to sit. Rather, it was information revelatory of what was going on inside the home. So, 5-4 decision, an important victory for Fourth Amendment rights. Thank you.